And that was the opening statement by Shayna Huber's defense attorney. And you heard what he had to say, which is, hey, this is not the relationship that prosecution has tried to paint a picture of. Instead, physical attacks by the victim, now deceased, on her. And that he forced her to engage in sexual acts, throwing her around. All of these descriptions. Ross Kramer, criminal defense attorney, is our special guest today. Thanks for joining us. Always
Anytime.
love having you.
Yeah.
So talk to us first about the prosecution opening. You made a comment on one of the breaks while we were watching. What did you think of the opening statement by the prosecution?
I thought it was effective, but I thought it went too far. And here's why. It is, in most cases, objectionable and almost grounds for a mistrial in an opening statement for a prosecutor to presume that the defense is going to call any witnesses or what those witnesses are going to say. So in our system, in criminal cases, the defense has no obligation to call any witnesses or put on any defense. It's solely the prosecution's burden to prove their case. So generally, if the prosecution theorizes about a witness they're going to call or an argument they're going to make, a defense attorney is up on his feet screaming objection and asking for a mistrial. That didn't happen here as far as we could see.
All right, so we're going to talk more about that on another break, because I'm going to ask Mr. Kramer, what exactly would you have done if it were you? Would you have mounted that defense during an opening? Because typically during opening statements, so long as you stay within the parameters of what's allowed, it doesn't draw an objection and you don't necessarily want to interrupt. But did it go too far? Should defense have objected? We're going to turn back to this trial after this break. Please rejoin. Welcome back to Law and Crime. I'm Judge Ashley Wilcox. So we are looking at female felons on our replays, and this one is about Shayna Hubers. Now, again, the question's going to become for the jury. Was it self-defense when she shot and killed her boyfriend? Or was she a victim of abuse? Was it self-defense because she was a victim of abuse? Or did she murder her boyfriend? We are going to listen to one of the witnesses from law enforcement. This is Officer Ensweiler with the Northern Kentucky University Police Department testifying in her case.
She had mentioned something about, is he dead? And did you see the white sheet over him? But I don't remember exactly what she said about it.
Did she say anything specifically about where the shots were fired?
Yes, she said she thought she shot him in the face and in the chest, but she didn't remember which one was first.
What else did she say about the locations where she believes she shot him?
She had made a comment about shooting him in the nose, and I think this was on the recording as well, but she gave him the nose job that he always wanted.
You had mentioned, she said something about emotional abuse during this period of time before you get into the recording room. Did she say anything to you about physical abuse?
No.
You remember her emotional abuse, and you remember nothing about physical abuse?
Objection, ask and answer.
Overruled. Go ahead.
Thank you, Your Honor. Is that what you remember?
That's correct.
Okay. Anything that you remember as it relates to Mr. Posted in guns?
That he was a gun freak, I think is what she called it. Mm-hmm. A gun freak or a gun fanatic, I can't remember what the terminology was. But that it was funny that the guns he loved so much killed him.
It's funny. At this point, Your Honor, I don't have anything.
So that was testimony from Officer Ensweiler, and she interviewed Shayna Huber, the defendant, shortly thereafter when it happened. And so a couple of things that I want to point out, and then I want Ross Kramer, our expert's opinion on these things. First of all, she did say no, Shayna didn't report any physical abuse by the victim and did not remember if she shot him in the face or the chest. But Ross, I do note that she was able to say, but I gave him the nose job he always wanted. To me, it doesn't sound real credible to hear that she said, I don't remember if I shot him in the face or the chest first. What's your opinion?
Well, I think that the key to this was more the tone and attitude of the interaction that they had. She wasn't describing somebody who was completely broken up about this, who had just come out of a physical altercation, killed her boyfriend. Most people would have been panicked, in shock, in a real upset state, talking about what happened. This seems like very flip comments from the defendant, and I know that's repeated later on the videotape that we'll see. But you know, I think the overall tone here that this witness is trying to relay is one of someone you would not expect to have come out of a very traumatic event.
So what do you do with that as a defense attorney? If you have a statement that's been given, you can't change it, they acted like they acted, but how do you offset that in mounting a defense?
Well, I think that's very difficult here with a witness like this who has no stake in the game, who has no bias. You can do it with some of the later witnesses, jailhouse informants, things like that, who have a motive to testify falsely. With a police officer like this, you have to kind of attack her recollection and the fact that this was 6 years prior, and couldn't she just have been remembering the things that she saw on the videotape as opposed to her own recollection? All
right, so now we're going to get into testimony that's going to give us more information about the actual injuries, and this is testimony by the medical examiner.
Would it be safe to say that Mr. Poston was alive for each
Yes.
of these shots?
Yes.
Within a reasonable degree of medical certainty?
Yes.
If someone had said that the first shot that Mr. Poston received was, I think we refer to it as the right temple.
Yes.
I think that's what you referred to it as. And after that shot, he was twitching. From a medical perspective, what does that say to you?
Well, Mr. Poston had severe brain injury. The brain can react to severe injury by having seizures. And seizures may be everything from staring to flailing your arms and legs to twitching to uttering things. All those things can occur when the brain's firing off and having a seizure. So brain injury can cause a seizure. He certainly had brain injury. So if someone says that he is twitching, he's probably having a seizure.
Dr. Wenger, the medical examiner, states that there was a shot and then he was twitching caused by seizures. In your experience, have you ever had defendants who have been killed and they have twitches after they've been killed or shot?
I haven't seen that, but what I would want to see from this witness is sort of what position the decedent was in when he was shot. I mean, if he was shot once while he was standing up and then fell down, and she continued to shoot him, and they could tell what angle bullets entered someone from, and they could see on the floor if a bullet made an impact. You know, that would be very different in a self-defense case. If he was alive, as this medical examiner said, when all of these shots were fired, if you're trying to defend yourself and get someone off of you, I don't know why you would keep shooting them at a point when they were already no threat to you. I think that would be an important part of this testimony.
Right, and you said something I was going to draw our attention to, and that is all the shots, because you're right. She was shooting, she shot him 6 times. Not once, not twice, self-defense, but a total of 6 times. And so the medical examiner can explain 6 shots and which shot may have been the one that actually killed him. But it's overkill. I mean, that's what the term of art a lot of people use when a murder is committed in a way that's pretty brutal. 6 shots.
We see this in so many cases here on the network. We saw this in the Van Dyke case. We see this in other officer shooting cases where the first shot may have been arguably justifiable when there's a threat to someone's life or to someone's safety. But how do you explain the shots after that? What's the point? How is that reasonable force to protect yourself?
Ross, where's my defense attorney? I'm waiting for you to defend her and say, hey, this is absolutely possible.
We'll see how it goes.
But yeah, it's an interesting set of facts. What happens? Does she actually get convicted or not? Does a jury find based on all the evidence that they hear? Juries are sophisticated, and I think that sometimes people underestimate juries and their ability to listen to the evidence and apply the law to the facts as they've heard them to make a decision. So we're going to find out what they do in this particular case. After this break, come back and we'll join more testimony. Welcome back to Law and Crime. So one of the other themes that we've had throughout our day today are retrials, and Shayna Hubers is no different. Remember, she was convicted of murder, and then after that it was learned that one of the jurors had not disclosed criminal history, and so it was overturned and she's being retried. We are looking at the testimony and that retrial today and the pieces we've been watching and are going to continue to watch. So the next piece of this case is the law enforcement investigation. As we all know, in any any criminal case, murder case, there is a law enforcement investigation. So we're going to listen to testimony from Lieutenant David Fornash, who's the Highland Heights Police Department, and how he played into the law enforcement investigation in this case.
One of the things that we talked about is with Ms. Huber's, in her statement, saying, I'll use her words, thrown around the room like a rag doll, thrown into the bookcase. What was one of your concerns as an investigator when you see this scene?
That there was nothing knocked down on the shelf.
Nothing knocked down on the shelf when you first came?
Correct. There was dust. If you look up on top, there's a card. There's items that could have been knocked over.
Here it's like a birthday card
Some type
or...
of card. Yes, ma'am.
Okay. And nothing at that point in time was out.
That was testimony from the investigator. Now we're also going to play some testimony from another law enforcement officer, Bill Birkenhauer from Highland Heights Police, and he was the chief of police, and let's hear what he did as his part in this investigation.
We've heard a little bit about the defendant going to the firing range.
Yes.
Are you aware of that incident?
Yes, I am.
Through the course of your investigation, did you learn who it was that was attempting to arrange that day at the range?
Shayna Huber sent a lot of messages asking Ryan to go to the range. First, she started off asking a friend, Tom Awadaba, to join him. And she kept asking Ryan. Ryan was busy on, I think, the 1st of October and the 2nd. And after asking her quite a few text messages requesting from Shayna Huber to go to the range, they agreed and went on October 3rd.
Let's talk a little bit about October 11th, the day before Mr. Poston was shot and killed. Are you aware of what happened earlier that week between the two of them?
Well, Shayna Huber's had been calling Ryan, asking to go out on a date, to go see the movie, take him to and go to dinner. I think he acknowledged that he would do that. She sent multiple messages trying to lock down the date and time and where they were going and such like that.
Okay. So that was her idea to go to a movie?
Yes, clearly.
And then we heard that later the plans changed.
Correct.
Okay.
And there we have more portions of the law enforcement investigation. Ross, I just have to ask, you just heard him say on the texts that there was a message about going to the movies. He said he'd take her, and then she sent multiple messages trying to lock that down. All right, let's be honest. If someone says, yes, I'm going to take you to a movie, and that doesn't go any further, doesn't that mean it's not going to get scheduled, it's not going to happen, it must not be as important to that person as you might think it is?
Yeah, look, I mean, I think that the text messages here went even further than that. There were text messages where, I think he was trying to break up with her, and she said she would keep crying until he took her back. I think there were a lot of text messages in this case that really were important to show her contemporaneous thinking, her emotions at the time, and the relationship between the two of them as she expressed it to him and as she expressed it to other people. That's really important evidence because as the lawyer said in opening, years later, they could be revisionist history. But this is what they said, what they were thinking at the time.
Okay, so then that's followed by this text. I'm not going to turn down learning to shoot a gun when there's correspondence with him about him taking her to the gun range. So first you have the personality that you've described based on the text, and now you have this statement. Does it trigger any concerns in your mind at this point that someone wants to learn how to shoot a gun or isn't going to turn it down or not?
I don't think so. I mean, if this is not necessarily, to me in itself, that powerful evidence because she would say that he was really into guns. If she wanted to be with him, maybe it was something she wanted to participate in with him. I think that the prosecution is probably not going to make too much of that because there's a lot of ways to view that. But just think of it. How did prosecution prove cases before there were text messages and emails?
That's right.
Crazy to think.
Yeah, it is. It absolutely is. And not only that, but in this case, one of the things that the inconsistency pointed out, and this was always done with pictures, right? That's a picture's worth 1,000 words because here her statement was to law enforcement, he threw me around like a rag doll, and that's why I had to shoot him in self-defense. But they showed pictures, and the first responders said, yes, everything's on the shelves, nothing's awry in the room. To me, that's some of the most damaging damning evidence you can have.
Absolutely. I mean, signs of a struggle. That's always the headline you see in newspapers and you see on videos when they're talking about, a self-defense case or when there was physical abuse. Here, if investigators are going to say there were no signs of a struggle, that's big evidence too.
Right. So, Ross, you've just identified, I think, our next theme on Law and Crime, and that is the day of how social media affected defendants and whether or not they're convicted. Because it's true, the text messages, social media, all of those things make such an appearance in these cases. So stay tuned. We're going to continue to look at the retrial of Shayna Hubers when we come back from this short break.
Did Mr. Posen express to you what he was intending on doing that week as it relates to his situation with the defendant?
Oh, he's breaking up with her. That was it. Things were doing so well for him at the moment, and it was time to move forward in a positive direction. He was absolutely going to break up with her, and this time what was going to be different was he's breaking up with her face to face, so he can make it clear he's going to get a backbone with it and stand firm on it, because the other ways he did it didn't seem to work.
So let's talk about that. The other ways he did it didn't seem to work. What do you mean?
First, he was trying to give her hints or infer. Most of it was text. There was a lot of it.
Well, Ryan's testimony certainly paints a different picture, and that picture is, hey, she was the one that wouldn't go away. He tried to break up with her. She was kind of crazy. She'd show up. He had to do it face to face. Credible or not, that testimony from your expert perspective as a defense attorney?
I didn't like the personality of that last witness, but you take the witnesses as you find them. And, I think it was useful testimony to some extent, but then again, it turns it around the other way. If, a good defense attorney could turn it around the other way, and the idea would be that if this was such a wild ride, a roller coaster relationship, you could certainly see her showing up at his house when he didn't want her there and it turning into a verbal and physical altercation. So showing that there were fireworks here, that there were problems here. I don't know that it's totally one-sided testimony favoring the prosecution.
Well, let me ask you this. Just if you look at those three witnesses in terms of how the actions were between him and her, is that really relevant for the actual conviction phase and determining whether or not she committed murder?
So a motive is never an element of a crime. It's not something the prosecution has to prove. But in the prosecution to get a conviction, what they're trying to do is tell a story that convinces a jury. And what you have to do to tell a story is to show not just what happened, but why it happened. So showing the background and the motive is often very important for a prosecution.
All right. So just to recap, this is Shayna Hubers, the Kentucky case. She was convicted of murder in this case for killing her boyfriend. Then that conviction was overturned because it was learned a juror did not reveal they were a convicted felon. That is something, yes, a jury member needs to share when asked, and they didn't. Overturned, retried in 2018. You will not want to miss after this break. We are going to hear directly from the mouth of Shayna Hubers when she testifies. So please come back, join us. Let's hear what she has to say and why it was self-defense. We'll be right back. Thank you, Anthony Velez, for those top crimes from around the nation. I will say, it seems like we see one or two kinds of stories. One is, the first is, killing of spouses and children and those related to them. The other one are these innocent victims, Ross. So today we saw how the manicurist, they tried to run over her when their debit card or credit card was denied. How do you, is there any preventing that type of crime? What do you do? It's almost like you're innocent, damned if you do, damned if you don't.
I mean, I think the mental health treatment in this country probably isn't what it should be. This was a stolen car. This is somebody who was they showed her mugshot. I mean, this is somebody who may have been released maybe too early from incarceration. There are a lot of issues here. These are huge sociological issues about why these people are on the streets. Yeah. So we appreciate, Anthony, as always, your great coverage of those crimes. Now we're going to return to Kentucky versus Shayna Hubers. And again, this is what you're just not going to want to miss, because this is when Shayna testifies. Let's hear what she has to say about what happened on that fatal night.
Did you all have any private conversations at that time?
Yes, sir.
And did you all go anywhere else together?
Yes.
Ryan met me at the restaurant bar that I was having the party at is called Tin Roof. It was fairly new back then. This is a long time ago. He wanted me to leave Tin Roof with him and go to a different location, like 2 doors down. And as we were leaving the bar, I remember he grabbed onto my wrist really with a strong grip and was walking ahead of me down the street towards, I believe it was called Two Keys Tavern at the time. And I remember thinking that he had a strong personality and was, I feared him. I felt like I needed to do what he was telling me to do. I went on to bed. I woke up for whatever reason. I had a chair like this one, like at my computer table next to my bed. And I woke up and he was sitting in my computer table at the chair, watching me sleep. I don't know if he was also playing around the computer because he couldn't sleep or what, but he was sitting in the chair watching me sleep. And he said, "I can't sleep on the couch. Is it okay if I get in bed with you?" And I remember saying, yeah, but I really do just want to sleep. Like, I have to get up tomorrow and study for school or something like that. And I allowed him to get in the bed with me. One thing led to another, and he wanted to mess around with me. And
was that okay with you at the beginning?
At the beginning, it was.
So that is the defendant, Shayna Hubers, testifying, and she's painting a picture. She started with the very first night that she met the victim, Ryan Poston, and saying, hey, when I met him on that night, I felt like he was telling me what I had to do, and I had to sit on this side of the booth, and painting him as controlling. Now, one thing as a reminder, this is the retrial in 2018, because she was convicted of murder previously. She was sentenced to 40 years in prison, and that conviction was overturned. And I want to return to one of the comments made by our analyst, Kramer, and what you said about social media. And we've talked about how prosecution can use that social media texts to really prove their case. But how does the defense use it, and how did the defense probably use it in order to find out that one of the jurors actually was a convicted felon?
Well, the way defense counsel uses it at trial is a little different. It's almost malpractice at this point. If in a big trial with serious consequences, you don't hire an investigator, you don't do some sort of investigation to find out social media postings, what people are putting on Facebook, on Twitter, just do a full workup on someone that's going to be a witness against you or as a victim or as a perpetrator. But to find out about jury misconduct, it's a little bit different. Usually after a trial, if you have a suspicion that there could have been something strange about a juror, you can go back and look at their background. A lot of times other jurors will whistleblow on a juror and say, listen, I'm coming to the defense attorney's office to tell you during the trial, this juror was on Twitter posting about the trial and getting replies. So she was actually bringing other people's opinions into the jury room. I've had those cases, and they've been kicked off by other jurors, and we've gotten convictions overturned because of it.
And so, that's one thing about our jury system that I respect and believe in our justice system, because it's good to hear that jurors take their job seriously, and they will whistleblow, they will report if things happen. And so that's how our system is supposed to work. Now, remember, this was the retrial in 2018 when she chose to testify. She's painting the picture. And again, it was because of that conviction that of the convicted felon who was the juror who had not revealed that and should have, that it was overturned. So 2018 retrial, defense attorney, would you have called Shayna? Is there any way to look at it and say, well, I would or wouldn't have?
So this is one of the few choices in a criminal prosecution where a defense lawyer has to defer to a client, whether to take a plea and admit your guilt, and whether a defendant wants to testify on their own behalf. Often a judge will sit there with the jury out of the room and say, I want to talk to the defendant to make sure that she's being counseled and she understands that she has the opportunity to either testify or not testify at this trial.
To get breast implants, and he also put pressure on me to remain a certain size or lose weight. At one point, I lost weight for him, and he told me I was too skinny and to gain weight. He was always very particular about my size and things of that nature. The orgasm thing was the most important, I believe.
And how would you describe your relationship going forward into 2012?
It wasn't the same as it had been before.
How so?
It was strained. Ryan went days without talking to me. I didn't know what he wanted from me. I began to see a couple other guys in Lexington. It ended.
Did you tell Mr. Poston that?
I told him that I was interested in a couple of guys in Lexington, and he told me not to pursue them, that he still was interested in me, that he still wanted me. We went out to dinner at Cloud9 Sushi in January of 2012, and I brought this up to him. I said, there's these men in Lexington I'm interested in, and I don't feel like you feel the same towards me. I don't know what you want from me or if you even want me anymore. And he said, no, I don't want you to see those guys.
So that is more testimony from Shayna Hubers, and we're going to take a break in a few minutes or seconds, and then we'll come back to that testimony. But one of the things that's interesting to point out is the prosecution started in their opening statement, which we showed, by saying there are a lot of inconsistencies in her story. So far, though, she's painting a picture of someone who appears to be somewhat controlling. In this recent testimony, she says, look, he told me I needed to get breast implants. Then he would say I needed to lose weight, I needed to gain weight. And so he was very particular and very controlling of me. And so it seems like she's painting this picture that's pretty damning, so to speak, of a controlling person who she felt like was putting pressure on her, and some could argue emotionally abusive. So that's the picture she's painted thus far. We're going to hear more testimony from her, and we're going to return to this replay, and this was a retrial from 2018. You will not want to miss continuing testimony directly from the defendant's mouth when we come back from this short break. All right, so Shayna Hubers continues to describe some of the sexual activity with the victim in this case, describing it as a way that he was controlling her, and some other incidents that happened at Final Four and a basketball game in Lexington. Ross, let's talk about one of the things you mentioned on a break, and that is, she appears to be fairly credible on direct examination, but a lot of the legal pundits had said, you know what, she made so many comments in the past that played poorly with the jury. There's absolutely no reason that she should testify in this retrial in 2018. Why not? What are the risks that she runs?
Well, the reason you would not testify, the reason you would testify in a case like this is if you felt at the close of the prosecution's evidence that you didn't have a realistic shot to be acquitted. So it's almost a decision of necessity in a case like this. I think she's doing well so far on direct examination, but like we had talked about, this is something that her and her attorney had probably worked on for weeks, if not months, scripting this, going over the questions that were going to be asked, what her answers would be, how she would answer them, down to her inflections in answering them, and her demeanor and the way she would come across. The real test is not her direct, which is essentially how she would act if this was a movie of her life. It comes in cross-examination when she's asked tough questions, when she's asked questions she's not expecting. And you see how her demeanor changes, how she deals with that, with the inconsistencies with what she may have said before to what she's testifying to in 2018. That's going to really show how successful her testimony may be.
So let me ask you, when there are inconsistent statements or statements that sound really bad, things like he always he just got the nose job he always wanted when she shot him in the face. Are those things that you prepare your witness for and make sure that you get those questions out on direct to soften the blow, so to speak?
Oh, absolutely. I mean, that's called, pulling the sting. You don't want the other side to bring that up for two reasons. One, you want to control the narrative and have your witness answer it in the way you want to answer it. Number two, you don't want the implication later that you were trying to hide these bad facts from the jury, because a defense lawyer at the end of the case can say, you know what, you heard 6 hours of testimony from this woman. Her lawyer didn't even ask her about these bad things. I had to come up there. They were trying to hide that from you. I had to be the one to bring that to light. So there are a lot of reasons why you want to control the narrative and ask those tough questions yourself.
All right. So I know as a judge, I've listened to a defendant and they've said something and I'm like, I can't believe they just said that. We're going to talk a little bit later about, does that happen? Do defendants get up there and say something that they weren't prepared, or the defense attorney wasn't prepared for them to say? We're going to take a short break and we'll be back right after this to continue with Shayna Hubers.